Good afternoon. I'm Jim Turk, Director of the Center for Free Expression, and would like to welcome you to today's session, which is the 10th in the Center's series entitled Taming Big Tech, Exploring the Alternatives. The title for today's event is Privacy Compromised. Will Bill C-27 protect Canadians' privacy rights? But before we go into that, I want to begin by acknowledging that the land on which I am speaking to you today is the traditional territory of many nations: the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. And I also want to acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit, and the Williams Treaty signed by multiple Mississaugas and Chippewa bands. I also want to thank our co-sponsor for today's discussion, the Canadian Civil Liberties Association, the Edmonton Public Library, the Milton, Ontario Public Library, Open Media, Toronto Public Library, and the Vancouver Public Library. Today, we're going to be looking at the issue of privacy protection for Canadians. The federal government has introduced Bill C-27 to strengthen Canada's private sector privacy law. The bill actually proposes to create three new acts. One, the Consumer Privacy Protection Act, to make changes to the present privacy law in Canada. Secondly, the Personal Information and Data Protection Tribunal Act, which would establish an administrative tribunal to review certain decisions made by the Privacy Commissioner of Canada and allow orders for contraventions of the new Consumer Privacy Protection Act. And the Artificial Intelligence and Data Act, which is to create new rules for the development and use of artificial intelligence. A lot is at stake for Canadians in this legislation, but it's opaque to many people. The CFE has arranged today's conversation to clarify what the government is proposing to do, what it means for us, what's good about it, what's bad, and what more is needed. Our featured guest in this conversation is Teresa Scassa. Welcome, Teresa.
Hello, it's great to be here.
Teresa is the Canada Research Chair in Information Law and Policy at the University of Ottawa Faculty of Law. She's the author of co-author of several books, including the award-winning Electronic Commerce and Internet Law in Canada. She's a past member of the External Advisory Committee of the Office of the Privacy Commissioner of Canada and of the Government of Canada Advisory Committee on Open Government. She also writes a really wonderful and informative blog, which you can see on her website at Teresa Scassa, TeresaScassa.ca. Welcome, Teresa.
Thank you.
In conversation with Teresa will be the host of our Taming Big Tech, Exploring the Alternative series, Andrew Clement. Andrew is Professor Emeritus in the Faculty of Information at the University of Toronto, where he coordinates the Information Policy Research Program and co-founded the Identity, Privacy, and Security Institute. Andrew has a PhD in computer science and has had longstanding research and teaching interests in the social implications of information communication technologies and of participatory design. Welcome, Andrew.
Good to be here, Jim.
We're happy to see you again. The format for the audience, the format for today's discussion is Andrew and Teresa are going to have a conversation for about 45-50 minutes or so, after which we're going to turn to the audience for any questions you may have for the two of them. If you look at the bottom of your screen, you'll see there's a Q&A button. And in this version of Zoom webinar, you can, at any time as you're listening to their conversation, a question comes to mind, click on the Q&A button and simply write down the question that you'd like them to address when we move to the audience question part of it. Don't wait till we go there. As questions come up in their conversation, just jot them down under Q&A. And Ange Holmes, who is the center's coordinator, will read those questions to Teresa and Andrew when we come to that part of the program. That's all from me. So over to the two of you. Look forward to your conversation.
Thank you.
Well, thank you, Jim, and welcome, Teresa. And welcome to all of you out in Zoom land to the 10th installment of the Taming Big Tech series. I'm reaching you from the Mexican city of San Miguel de Allende in the ancestral homelands of the Chichimeca and other Nahuatl-speaking peoples. We're able to have this conversation thanks to a remarkable digital network whose physical features belie its popular characterization as a placeless cloud. In North America, at least, the fiber optic cables carrying the signals between us, as well as the switching centers and the electrical grid that powers these and other devices that we use, were pushed through vast lands seized by colonial agents from numerous First Peoples in more or less bloody ways. Teresa, I'm delighted to have this opportunity to explore with you Bill C-27, the Digital Charter Implementation Act, the long-awaited modernization of Canada's private sector privacy law, currently under debate by Parliament. Will it actually protect Canadians' privacy rights? All legislation involves some degree of compromise between contending interests, but will the ideals and legitimate expectations around privacy protection be significantly impaired in the process of developing this legislation? You bring a wealth of experience and invaluable legal perspective on what Canada might consider as it wrestles with updating its private sector privacy legislation. Your blog, as Jim mentioned, offers clear and incisive commentary on many areas of the law, most recently and specifically on many aspects of Bill 27 and its predecessor, C-11. So I'd like to start just by, to orient those who are not already familiar with Canada's private sector legislation around the issues that it needs to address in light of developments in the past 20 years since it was enacted and the current state of play. So, Teresa, could you start off by just giving us a quick overview of what PIPEDA, or the Personal Information Protection and Electronic Documents Act, that has governed private sector data protection in our country for the last 20 years. Could you give us a quick sort of nutshell in your view as to what it is and what it tries to do?
Yeah, so this law, which as you mentioned, it's 20 years old, and I think showing its age in some respects, was introduced at a time when electronic commerce was in its relative early days. And I think the government in enacting this legislation had a couple of concerns. One was to build trust, consumer trust in electronic commerce. In other words, the concern that people would not go online and shop online and do business online with their banks and so on if they felt that their personal data were not protected. So one dimension was to build trust in electronic commerce in order to facilitate that the development of those industries. And the other, of course, was the specter of the European Union looming over us with their data protection directive, as it was called at the time, which promised to limit the flow of data out of the EU into Canada for commercial purposes, unless into any other country, not just Canada, unless there was adequate data protection in that country. So it served those two purposes. And it's interesting to think about that comparison with where we are today, where now the concern is fostering trust and facilitating the use of data to support the burgeoning AI industry. On the one hand, and on the other, looming over us the threat of the failure of an adequate, potential failure of an adequate assessment with the EU's GDPR, which is their next generation data protection regulation, which has considerably enhanced, changed, and improved data protection for the data context in which we find ourselves. So that's a little bit of where we are with the reform of PIPEDA. It was introduced for, in a particular context. It was controversial at the time, and we're seeing the same sorts of arguments today. There were concerns that data protection law would stifle innovation. Same arguments were made at that time. And so we'd want nothing more than kind of a light touch approach. We also didn't want to stifle or suppress small and medium-sized businesses or overburden them with excessive regulation. We see those same arguments being made today. And so that informed many of the choices around what kind of data protection law we would have then. So we're revisiting many of those arguments today, but in a very different data and technological context.
Yes, well, thank you. Yeah, the stated purpose of PIPEDA at the time was to encourage electronic commerce. That was the sort of the leading purpose, and that purpose is still figured prominently in current Bill C-27, as you know, and the model that PIPEDA adopted, as you said, with a light touch. It's also consent-based, that it assumes that there's consumers who can make choices about whether they're going to use a service or not, based on information that's provided by the service, and then if they don't like it, they have to complain first to the company, then to the privacy commissioner, and the privacy commissioner, as I understand it, was figured as a kind of an ombudsman to sort of settle disputes between the individuals and the companies that had their data. And that strikes me, well, I thought it was out of date at the time, just given the enormous sort of power asymmetries between individuals and at least large companies. And if anything, that has been exacerbated. And so I wonder if what you think of how that has actually worked out, and in particular, whether the restrictions or the say that limited model came about due to sort of certain complexities of Canada's constitutional status, with the division of powers between the federal and the provincial government, or whether that reflected sort of what I would think is perhaps more a factor, which is just business interest in wanting to have sort of minimum obstacles to their own commercial activity.
Yeah, well, I mean, to start with, I think there is a role for a variety of different regulatory approaches and tools in the Privacy Commissioner's toolbox. And so the soft compliance model has worked in many cases. Most complaints are resolved, for example, to the Commissioner, are resolved without having to go to court for orders, or resolved without necessarily even leading to an investigation and findings. There are mediation processes and other ways of addressing and dealing with complaints, and complaints are going to vary quite considerably. In some cases, there's been an honest mistake. In some cases, it's clearly a lack of certain policies or practices, and that can be corrected. And so we see this across all kinds of data protection laws that we have in Canada, where there are different ways to resolve the problems that don't necessarily have to be highly conflictual. But we're also increasingly seeing fairly exploitative and extractive data practices that really underscore what you describe as this imbalance of power, and which really call out for perhaps more stern enforcement measures. There's also a tremendous amount of money to be made from the continual and ubiquitous collection of personal data, and the exploitation of those personal data for a variety of different purposes. I mean, these are business models are now built on data. We've moved from a context in which you were providing personal information in order to receive a specific service, and we're now in a context where your data are being harvested in ways that may not even be particularly apparent to you, and have a commercial value and are being exploited in a variety of different ways. And so in that context, I think there's a growing need for other tools in the toolbox, more flexible tools, and sometimes more punitive tools where things go badly astray, so that there is much more of an incentive to comply with these laws. It's a little bit of, you'll remember the Ford Pinto, right? It's a little bit of this, the idea that, if there aren't any consequences, you don't have to fix problems. You can just say, it's the cost of doing business, and we'll just absorb this, unless you're facing, for example, significant administrative monetary penalties, at which point you might say, well, okay, we're going to have to be a bit more careful and a bit more compliant with what we do. So I think we're in an era now where the stakes have changed. And so not to knock the soft compliance part, there's a role for that, but there's also now clearly a role for much sterner measures and more punitive measures at the other end of the spectrum.
Mm-hmm. And you can see some of that in C-27, and we'll get into that in a moment. But I'd like to pick up on your point about the sort of shift in business models and the much greater data appetite that we're as consumers or individuals are facing. And I'd like to draw upon our sort of shared experience as we both were on what was called the Digital Strategy Advisory Panel for Waterfront Toronto when it was working with Sidewalk Labs, a Google, well, it was a sister company, I guess, technically it's part of Alphabet, in proposing to build a sort of quote smart city from the internet up in the waterfront area of Toronto, and that was kind of a big deal at the time. It ultimately didn't go ahead in May of 2020, but for 2 years we were both sort of witnesses, as were many Torontonians, to a kind of a vision of data capture and use, which I'd be interested in your reflections on what that suggested about both the sort of the current role that data and industry is playing, with Google as being a kind of an outstanding exemplar, and also where we might be headed. So if we're thinking of legislation that's going to last a few years, we have to sort of look ahead to what are we going to be dealing with, and I wonder if you could comment on that.
Yeah, well, there's a lot in there. I mean, one of the things that I thought was really interesting about the experience with the Sidewalk Toronto project was how initially the concept of or the idea of what individual concerns would be around privacy was a very narrow one. And so in the early days, it was just, sure, there'll be personal data collected, but don't worry, it'll be anonymized or de-identified at source. And so therefore there aren't any privacy issues. And it quickly became, as there was more and more public engagement and public input, that it quickly became clear that there were kind of a broad range of different interests and concerns that included privacy, that went beyond privacy. And I think all of these inform the discussions and debates we have around data protection. So for example, there were questions about access to data for a variety of different purposes, including for public or socially beneficial purposes. So if all of these data were being collected in this space, you know, what arrangements would be made for other local developers, for example, to have access to those data, to do their own development, which would be in the local public interest? What about the ability of the city to make use of those data? Or and so there were questions about who would be able to access data and under what conditions. And I think that there are elements of that in Bill C-27, or elements trying to address some of those issues in Bill C-27. But beyond that, on the privacy side, it was also very clear that people were not satisfied that anonymization or de-identification was going to be sufficient. And I think we've reached a stage where it's clear that both the sheer volume of data that are collected and that are available and the power of the technologies that we're dealing with make re-identification a real risk. And so that was not sufficient as an assurance. And we have de-identification and anonymization issues that surface in Bill C-27 in an attempt to grapple with that. And then beyond that, what we started to see in the Sidewalk Toronto context were concerns that went beyond individual privacy with respect to data. In other words, even if data were perfectly anonymized and incapable of being linked back to specific individuals, they could still be used in their de-identified or anonymized format to impact individuals, because they could be used to profile individuals who were associated with particular areas or communities or likes or interests, or they could be used to make decisions about communities. And so we start to see a broader concern about group or collective impacts on privacy. And this debate is also surfacing in the context of C-27, particularly the part dealing with AI and data. So I think those are some of the things that I saw coming out of the Sidewalk Toronto discussions that I think reflect changes in how we think about data, about privacy, about the competing interests. And I think some of those we see in C-27, with greater or lesser degrees, I suppose, of elegance in C-27.
Mm-hmm. Well, let's get into C-27 and particularly its first part, the Consumer Privacy Protection Act, which is the sort of the successor to PIPEDA, and we'll get into the other two parts later. I guess the first thing to say is or ask about is how does it actually improve on PIPEDA? Has the government listened to concerns? And I'm thinking specifically of order-making powers and fines, or as they called administrative monetary penalties. Those seem to shift, as you were suggesting, away from a sort of a light touch model to where the privacy commissioner actually could have some clout in a way that they never had before. And the privacy commissioner has been asking this for a long time. So we've got that in C-27. Can you look at other areas where they've made advances that give encouragement, put it that way?
Yeah, well, I mean, it's interesting. There certainly have been attempts to address and deal with certain problems, but I mean, you've mentioned the administrative monetary penalties, and we've certainly seen over the last few years some pretty egregious misuses of data in contexts where there's been an investigation, there's been a report, the privacy commissioner has found breaches. The breaches have been of, in some cases of a shocking and scandalous nature. And the privacy commissioner can make recommendations. And the company, yes, the company can also, and some companies have in some cases, can also say, you're wrong, we don't agree, or whatever.
Yeah. Whatever.
And so in a sense, this has provoked some public outcry against the legislation. And that's partly why we have these administrative monetary penalties. And so, it certainly looks like much more strict enforcement, but the reality is that so much of what's taking place is not ever going to be dealt with by those administrative monetary penalties. And so the privacy commissioner had been asking for more powers for proactive enforcement to ensure, and in a sense, it's a kind of a risk-based approach to ensure that things don't get to that point. And so these are some of the things that are not present in C-27, for example. So proactive audits, for example, where the commissioner could simply just decide that this year the commission is interested in mobility apps and maybe do proactive audits of mobility apps to see the extent to which they are protecting the fairly sensitive location data. But proactive audits are not in the legislation. The commissioner will be able to audit where there are reasonable grounds to believe that something has gone off the rails, essentially. And so, that's a very different kind of compliance. And there are, the requirements for privacy impact assessments. So for organizations to engage, and it can be tailored according to the size of the organization, but for organizations to engage in assessing the impact of certain data collection or data use programs before launching them. And so those are some gaps in the legislation, I think, that are unfortunate that we're not seeing, and we talked earlier about the privacy toolbox of the commissioner and the different tools that the commissioner might need in order to address a very different data collection and use environment in which we find ourselves. There are some things that have been added or changed to the legislation, but it's a mixed bag. And I mean, you know, there are, and with, I think with everything, there's good and bad. So for example, there are more things that are designed to give control to individuals. There's a provision, the EU introduced data portability, the idea that individuals could port their data from one organization to another, giving individuals more control over their data and fostering greater, in theory, greater competition. We have data mobility in the legislation, but it's a very different vision of data mobility. And arguably, perhaps ultimately more effective, but in any event, it's a very different vision. We have the right of erasure, the right to, it's not the right to be forgotten, but the right to go to an organization saying, I'm done with you, delete the personal data you have about me. But that's been heavily qualified as well. So there are new rights, there are new measures within the legislation, but they're always, you know, there's always this balance that's being struck. And so I think the issue becomes, how well has that balance actually been struck? Within the bill?
Yes, indeed. I was interested, as I think many were, that the former commissioner, Teresa, but while in some ways getting the, at least in partial form, the big items on that, on his wish list, eventually came out and said that overall, and this was C-11, the predecessor to C-27, was a step back overall. And so suggesting that we would be better with PIPEDA than the C-11. You've touched on some of the things. Can you say anything more about what why you think that he made that statement, which was, I would say, surprising?
Yeah, well, certainly the having more tools in the toolbox was one of the concerns of the Privacy Commissioner with respect to Bill C-11. But another concern, and this one you've raised already, is the human rights-based approach to privacy and the issue of the human rights-based approach. And the former commissioner was certainly a very passionate advocate for the need to take a human rights-based approach to privacy. And the current commissioner, the new commissioner, who has a background in human rights, the indications are that he also shares this view as well. So it'll be interesting to see how that unfolds as things move along. But the importance of this debate about the human rights-based approach to privacy is really this idea, because data protection laws, this is not just a privacy law, it's a data protection law. And data protection laws basically set the ground rules. The starting point is that organizations or governments, if it's public sector, organizations need to collect and use personal data for a variety of different purposes. And so these laws are not about protecting privacy, protecting people against those organizations' collection or use. It's about setting the ground rules for that collection or use. And there may be some things that are off limits, but it's really about, you know, providing a framework for an acceptable collection and use of personal data. And so the importance of the human rights-based approach is to not say, well, it's, you know, here, on the one hand, here are people who have lots of data, and here are organizations who want the data, and let's find a nice balance between the two. You know, let's look at the interests of the individual, and let's look at the interests of the organizations. The human rights-based approach has as the backstop fundamental human rights, right? So that there are going to be some things that even if an individual could consent to them, for example, you might not want an organization to be able to do, because it goes beyond the bounds of what would be acceptable in a free and democratic society, or there's the human rights become a backstop for and a line that can't be crossed when it comes to collection and use. And so it provides a conceptual framework in which it's not just individual interest in data, but there are individual interests in data, but there is also underneath that the fundamental human rights of the individual that can be very significantly affected by the ways in which data are collected and used. And so that, I think, was very important to the former commissioner, and may well be very important to the current commissioner. And so this has been a real point of tension in Bill C-11 and again in Bill C-27.
I mean, you've written arguing that it is quite possible for this legislation to adopt a fundamental human rights approach. The privacy commissioner has got a legal opinion of a sort, and we haven't heard anything from the federal government as to, at least in a strong and robust way, as to why they can't do that. And particularly since the minister and others have spoken about the need for Canada to maintain its compliance or equivalence with the European law, which does have human rights, fundamental human rights approach, as you say, as a backstop. What do you think could be done in order to get the federal government to move on this?
Yeah. So, and I don't think that the ideas that the federal government is opposed to the notion of privacy as a human right. And certainly the discussion paper, for example, on reform of the Federal Privacy Act talks about this. And there seems to be an openness to it in terms of the federal public sector law.
Mm-hmm.
The concern with the private sector law is the constitutional footing for the private sector law. When PIPEDA was first enacted, there were a lot of rumblings, particularly from the province of Quebec, that this was that regulating privacy, data protection in any way was outside federal competence. And the federal government built their constitutional competence to legislate in this area on something called the General Trade and Commerce Power. So I won't get into the weeds of the Constitution, but for it to be within federal jurisdiction, it has to address general trade and commerce. And I think there's this concern that putting a human rights spin on this approach to general trade and commerce might tip the balance towards unconstitutionality. I disagree. The law firm that wrote the legal opinion for the Privacy Commissioner, which you can find on the Privacy Commissioner's website, disagreed. But obviously, the industry departments sought legal opinions as well, and they must have come down on the other side. So this is one of the underlying tensions here, is whether you can do that. And I look at that and I think, well, if you can't do data protection backstopped by fundamental human right, well, what's the point?
Yeah.
At a certain level, that's what it's about. It's about protecting individuals from, certainly in our current data context, it's about protecting them from exploitation and abuse at one level, right? It's not all about that. Some of it is just kind of managing data, but there is definitely an element there that is to protect individuals against abuse and exploitation. So that's a bit of the dilemma. It's a Canadian problem.
Yeah, well, I've been listening to the debates recently, and the representative of the Bloc Québécois, or several of them, keep asking the minister, well, will this supersede Quebec law, which has a strong bill or act now already passed, and they keep getting reassured by the government that no, this is not going to step on Quebec's toes in this respect. So one has to wonder whether the government is more worried about businesses challenging them rather than the provinces. And given that the federal government hasn't published, as the commissioner has, a sort of a legal opinion justifying their reluctance to take this approach, it's a bit surprising. I mean, I don't know that you know of what's going on inside, so I know you can't answer that, but it's just a bit concerning, as you say, that like, what's the point in a way if you can't actually just provide this kind of fundamental backstop?
Yeah, well, the federal government has the Genetic Non-Discrimination Act was enacted. It was a private member's bill that was subject to a free vote in Parliament. It wasn't supported by the Liberal government because they were concerned that it would be unconstitutional. And it was a law that essentially, among other things, prohibited insurance companies and employers from requiring employees to provide genetic test information where it was available. And the concern was that people were having tests done for a variety of purposes, that they might be compelled to provide that and would have implications for them in terms of their employment or their insurance. And And the government was really concerned because employment and insurance are largely provincially regulated that this would overstep the limits of their constitutional authority. So they didn't actually support the legislation. It was voted in. The constitutionality was challenged. And again, the government wouldn't support it. The court had to appoint an amicus to represent or to support the constitutionality of the bill. And the Supreme Court, it went up to the Supreme Court of Canada, which found 5-4. So clearly it was a debatable issue, but 5-4 found that it was within federal jurisdiction. So, I mean, these are the stakes and these are the issues, but it's, great legal minds can differ as to what the outcome should be. But that's what we're facing here. It's this, can we go that far? Can we do that? Are we willing to give it a try? And what will the consequences be in terms of litigation? And you're absolutely right. A large multinational corporation that can certainly decide to challenge the legislation and tie it up in the courts for years. But.
Mm-hmm. One of the sort of new features of this bill, and the minister has made a fair amount about it in his speech to Parliament, is that for the first time it covers children or minors. But as many of the MPs have pointed out, and as we have in our report that we have contributed to by the Center for Digital Rights, the actual substance in the bill is around protecting minors is rather thin. They don't identify anything beyond a requirement that the data of minors be treated as sensitive without defining what's sensitive, and also they don't even define what minors are, and there's quite a bit of leeway in what that comes. So you want to say a bit about this? My previous guest, Elizabeth Denham, former Information Commissioner of the United Kingdom, made a strong case about this and has introduced legislation which has been passed and I think is used as a model. Do you think we should draw from, say, the UK or other jurisdictions in actually protecting minors? Because that's one of the big things that's happened since 2000, that previously it was assumed that data subjects were adults, and now there are so many who are not, and this seems to be a really undeveloped area. Yeah,
well, I mean, certainly the under PIPEDA, the Privacy Commissioner has issued guidance indicating that the personal information of children will be treated as sensitive information. And so that's been the case in terms of the interpretation and application of the existing data protection law by the Commissioner for many years now. And so in that sense, to sort of to put in the legislation that children's information is sensitive information doesn't actually change anything other than now it's in the law instead of being a matter of guidance by the Commissioner as to how the Commissioner will interpret and apply the law. So it certainly isn't a big change, but the children issue gets, this is also on the edges of the constitutional swamp in Canada, because it's the provinces that decide what the age of majority is, for example. And so starting to define the age of majority for the purposes of data collection starts to look like you're perhaps treading on provincial toes. And I suspect that is why there isn't more in this legislation, but certainly the trends internationally are to pay much more attention now to the privacy of children and impacts on the privacy of children. And you're even seeing efforts being made at the provincial level, because of course, during the pandemic, children spent a lot of time online for schooling, and schools were, using different online services and involving children in the use of those online services. And there was a lot of concern and attention over those. And so that's also starting to get more attention at the provincial level in terms of public institutions like schools. But in terms of the children's relationship with commercial entities, there's plenty of activity going on outside of Canada around that. And I think that the demand in Canada for something to be done to better protect children's privacy is certainly going to be there.
Yeah, good. Well, there's so many more aspects of this legislation we could be getting into, but I'd like to end on the consumer protection part by asking what you think of the situation of the Office of the Privacy Commissioner. It looks as though the this bill comes act will considerably expand the mandate of the Privacy Commissioner, but the resources of the Privacy Commissioner have not significantly expanded in over 10 years, and just in terms of budgets. And the Privacy Commissioner is spending approximately 50 cents per Canadian on privacy protection, which seems rather meager when you compare that over that period of time. The data giants have grown roughly exponentially, except for the last year or so. They've had some trouble, but Google gets $1 for a click-through ad, and Facebook until recently has been getting like $50 per person per year for the advertising that they're able to sell. So there's this power asymmetry between individuals and the Commission has grown enormously over the last decade. So what do you think might be done, at least in this legislation, that would give the Privacy Commissioner a better ability to to deploy the new powers? It's been given a few more teeth, but does it have a stronger jaw, as I think you commented at one point?
Yeah, well, I mean, I think that's the case with any administrative body or any department or agency. The budget is everything, right? You can enact the most beautiful piece of legislation imaginable, but if you don't provide a budget for it, an appropriate budget for it, then it is, the regulator is going to struggle to be effective at all. So budget is a very significant piece of this, and so it will be interesting to see what happens with that. I mean, we haven't talked about the tribunal or the things, but there's new infrastructure that's going to be created under the legislation, which comes with a price tag as well. So it'll be interesting to see if what happens with the budget of the commissioner or of the Office of the Privacy Commissioner of Canada, because that will be a really important signal, both in terms of how important these issues are to the government, but also to how effective enforcement and oversight of the legislation will be.
Mm-hmm. One of the things that Elizabeth Denham mentioned was that in the UK, the Commission earns money from the registration of companies. They have to pay an annual registration fee, which is relatively small, but given how many there are, it actually mounts up to be quite a sizable budget, proportionally much greater than the current one. What do you make of that idea, and whether you think that could work in Canada?
I'm not sure how easy that is to translate to the Canadian context. And you're also going to have, because we have again, it's a complicated constitutional context, but there are organizations, for example, that are going to be covered by law. So Quebec, Alberta, and British Columbia currently have their own private sector data protection laws that apply to certain matters, with PIPEDA applying to others. And then there are some areas of where I think concurrent jurisdiction is being exercised. So it's possible that an organization is subject to the Alberta law for some of its activities and to PIPEDA for other activities and so on. So within that context, that alone will complicate a registration scheme with respect to the legislation. I'm certainly, I think that we need perhaps more research and exploration of some of these different ideas within the Canadian context, and would certainly encourage any researchers out there who are listening and are interested in these issues to do some of that work. But I don't think it's necessarily an easy transplant into the Canadian context.
Yeah, no, I appreciate that. Well, we've still got two other parts to this bill, and unfortunately, we're going to be rather brief about them. The second part of the bill was this act to create a tribunal, which would review the recommendation, among other things, review the recommendations for these administrative penalties, and some have argued that this is, well, particularly the Privacy Commissioner, which says this will just slow things down and will not actually contribute significantly. What do you make of that, and what do you think should be done with this part of the legislation?
Yeah, I'm less troubled by having a panel established to set administrative monetary penalties than I am by having this be a tribunal that also hears appeals from findings and orders of the Privacy Commissioner. So the Commissioner has been given new order-making powers. You know, I think there might be some merit in seeing a little bit of distance between the imposition of substantial monetary penalties and a commissioner who is, you know, engaged in trying to resolve disputes and make recommendations and so on. But currently right now, commissioners in other provinces that have similar powers have or have similar legislation have order-making powers, and those powers are subject to judicial review. So somebody who feels that there's been an error or procedural unfairness or can go to court and ask for court to review that decision. But otherwise, you know, the commissioners address and deal with these issues under their own legislation. Setting up a tribunal structure, in addition to the expense, to me, it shifts the responsibility for the basic fundamental interpretation of the legislation to this mysterious body that's just been created away from the Privacy Commissioner, with a whole bunch of different consequences, because the Privacy Commissioner is supposed to have a role in administering, interpreting the legislation, and increasingly in matters that affect the country as a whole, the provincial commissioners and the federal commissioner have been cooperating on joint investigations and joint findings, which is, I think, certainly an interesting phenomenon. And it's one that helps to align the laws, the federal law and the laws of those provinces that have private sector data protection laws, to align their interpretation and application. And organizations are concerned about having to meet a variety of different standards in different provinces if they operate on a national basis. And so I would say that kind of collaboration or cooperation should be encouraged. And I also have concerns about, the commissioners who reach a joint, who carry out a joint investigation and release a set of findings where the federal commissioner's findings can be taken to a data tribunal that might overturn them or reverse them or change them. Well, what's that about? So, and how is that necessarily in the best interest? So I have some qualms and concerns about this. I see it as an unnecessary layer for the most part, and it will, of course, add to the time and trouble. And it's not just, it's the findings and the orders that can be challenged and appealed. An order is you're compelled to do something, but a finding is simply a finding that there's been a breach of the legislation. And so the fact that can then be appealed, I think, is just going to string out and delay processes substantially. So those are some of my concerns about it.
Yeah, we see in other jurisdictions, mainly in Europe, where Google and others of the big tech companies have been slapped with quite severe fines in the billions of euros, and they, of course, not surprisingly, take these to court and drag it out for years and years. And a commission of the resources that we have is unlikely to be able to mount a strong defense against that, or defend their position, or at least it would be a concern. I want to turn just now briefly to the last section, which is the Artificial Intelligence and Data Act, which a week or so ago was separated from the rest of Bill C-27 in the Commons because the NDP and the Conservatives, among others, wanted to vote on it separately, saying that they were rather separate and legal entities. You've written extensively on this, and as you mentioned at the beginning, I mean, this is the sort of the AI prospect is one of the main animating forces behind new concerns and modernization of legislation. So I wonder if you could comment at least briefly about this. I know you have a lot to say, but I personally think it's really immature. I mean, it's necessary kind of legislation to deal with what's called AI or algorithmic systems, but this version of it is, as the Bloc Québécois mentioned, is more draft than law. Do you agree? And what do you think should be done with it?
Yeah, well, certainly with PIPEDA reform, we had PIPEDA for 20 years. There were many reports and studies. There were many recommendations for reform of PIPEDA. We had Bill C-11, and there were discussions about C-11 and feedback, and the government went back to the drawing board and produced C-27. So this is something, that part, the Consumer Privacy Protection Act, is something that there's been a lot of back and forth and discussion about, and no bill or law is ever going to please everyone, but people have had their say. And I think that's really important. With the AI and Data Act, this took everybody by surprise. It's the first we've seen of it. There are huge gaps in it. And I think this is the hardest part, right? When I started reading it for the first time, I thought, I don't know what this law is about. I really don't. I mean, it's to govern high impact AI, but there's no definition of high impact AI. That's left to regulations. So much of the bill, the substantive content of the bill, is left to regulations. One of my blog posts, the first one I did, was statutory Mad Libs, where you just kind of fill in the blank.
I love that one. You should check it out. It's really, really good.
It was just, that came out of my initial frustration, where I'm trying to get my head around what this legislation is about, and so much of it isn't there. And so it's being left for regulations, and we're told, well, there'll be consultation on the regulations, so don't worry, you'll get your chance to have your say. The problem is that it bakes in a framework over which I think there's room for considerable discussion. And so we don't get to discuss the framework, some of the choices that are made there. And by the time it gets to regulations, it's too late to go back and talk about that. So I really think we need to, this one needs to go back to the drawing board, and people need to have more say and more input. All of the people who will be affected by this bill, from industry to individuals. There is an interesting intersection between the data protection law and the AI and Data Act. And that is that in the data protection law, anonymized data are very clearly out of scope of the data protection law. So if an organization has anonymized its data, the personal data it has collected, then that personal data falls outside of the scope of the legislation. And there's lots of debate and discussion you can have about that and the implications of that. But the AI and Data Act has provisions about the governance of anonymized data that are to be used in artificial intelligence. So there's meant to be that intersection. It's out of scope of one statute, but it's going to be covered by the other. And I have my own critique of that, and I think there are issues with that, and certainly not all anonymized data is going to be used in AI. And so, what about the rest of it? But there is that intersection between the two, this idea that with respect to data, at least, the AI and Data Act will pick up where the Consumer Privacy Protection Act leaves off. But anyway, it's really hard to know where to begin with that statute or that bill. But there's certainly, I would like to see a much more fulsome and robust discussion of some of the issues that it raises.
Yeah, great. Well, there's a huge amount more that we can talk about this legislation, but time is running out. And as we approach the end of the session, I hope that at least we've provided those of you joining us with plenty of ideas that invite some reaction. So I invite you to contribute to this discussion by posing a question in the Q&A link at the bottom of the screen. I see there's some questions there, but we welcome a lot more. So please do that. I usually ask my guest for some additional resources that they would suggest to help better understand this, and we'll certainly put some resources on the website in the future, and Teresa has kindly offered to some. But just in the interest of time, I want to turn this last question to what might be done, or what people might do, given that the legislation is in front of the House of Commons right now. It's at second reading. It's not likely to finish second reading by the end of this week, which is when Parliament retires until the end of January. So there's a whole month in there while it's in hiatus, but we expect it to come back in the spring. So there's an opportunity for people to weigh in on this. And so, Teresa, I would like to ask you finally, what first of all, do you think Canadians can expect C-27 to achieve an adequate level of data protection in light of the current circumstances, given how it's written? Or is it likely that the privacy will be compromised unless there are significant changes? And then what do you think Canadians can do to at least make it better, whether, however you answer that first question?
I mean, there's always a compromise with legislation of this kind, right? You can't have everything you want. And we certainly saw from Bill C-11 to Bill C-27 that the government was listening to both industry and to civil society groups that raised concerns and questions. So some of the amendments in the bill responded to civil society concerns. There were some exceptions to consent that you could drive a bus through, and those are gone. But you know, neither side got everything they wanted, and those debates and discussions are still ongoing and will be, you know, ongoing around C-27. So I think one thing that's important to think about here is what's, you know, if it doesn't pass, what's going to happen, and so there's a certain amount of pragmatism, I think, that's required. You know, PIPEDA has weaknesses and flaws too, and that's why we're reforming it, right? To bring it up to date with the current and contemporary situation. And if we don't pass C-27, when are we going to see another version of it? Are we going to see another version of it? Are we going to wait another, you know, how many years before we see something? So there's an element of pragmatism too. And so some of it is really, I think, thinking about, are there amendments that we need to make to this bill to continue to improve it, to get it over, you know, the hump, or to make it as good as possible, as privacy friendly as possible, in light of the fact that the alternative might be no change whatsoever. You know, so I think that's part of what we're looking at, and part of the engagement, the people's engagement in contacting their MPs, or you know, making submissions, or whatever people choose to do, is, you know, I think one thing that's important is to let politicians know that people do care about privacy. We're constantly being told, oh, people don't care about privacy anymore. Well, I think they do. And I think people are overwhelmed by it. I think people are, but when you see things blow up, like the TELUS mobility, or sort of the mobility data scandal around the Public Health Agency of Canada, people were really concerned about what was happening to their mobility data, and how it got into the hands of government, what was happening with it. There was a public outcry. People wanted to know what was happening to their personal data. And I think that, so, you know, I think it's wrong to say people don't care. It's just that people sometimes are unaware of all of the things that are happening, and overwhelmed by privacy policies and all sorts of other things, and also facing the reality of, you're working from home and your employer says you got to use Zoom, or you got to do a Google sort of a doodle poll, or you got to do this or that. I mean, are you going to sit and read the privacy policies and contact your employer and say, well, I'm concerned about, the transfer of my data to this company? You're not. You're just going to do what you have to do. And I think that so many of us are in that situation where we just are living our lives. So politicians need to know that we do care, contrary to popular messaging. We do care, that it is a matter of our human rights. It's not just about what data are used for what purposes. It is a matter about fundamental human rights and about protecting us from exploitation and abuse, discrimination. So these matters are important, and that there are ways to improve the bill. So yeah, I would say that this is it. It's before Parliament. MPs are starting to engage. They need to know that people care about these issues.
Well, okay, thank you. And on that note, let's open it up to questions. I see there are a few. So Ange, could we have the first question?
Yeah, and I do want to remind attendees, you can use the Q&A button to ask questions at this point. The first question is from Ali. The strength of these laws is reflected in enforcement. A tribunal to hear appeals will immediately undercut the power of the OPC. I'm concerned that this will quickly turn into penalties equated to the cost of doing business and not a deterrent. Shouldn't we be passing legislation to empower the OPC?
We should. And I think that some of the proactive enforcement tools that the Privacy Commissioner Teresa was looking for are very much in that vein. The idea that there can be proactive enforcement, that proactive audits, that that the Privacy Commissioner can have more of these types of tools, requirements for privacy impact assessments, requirements that they be provided to the Privacy Commissioner, all of these things. Not all are necessary or suitable to every circumstance, but to have those different tools in the toolbox can make an enormous difference. And we can't be overly focused on a complaints-driven process either. Just because the complaints-driven process arises where things have happened, right? Things have gone wrong and people are now complaining about it. Whereas some of the different tools in the toolbox will be ones that are aimed at addressing issues before they arise, making sure that things are privacy compliant at the design stage, or making sure that issues have been considered before a particular technology or service is launched. Or the commissioner going in and doing proactive audits to ensure that certain companies are in fact meeting the requirements of the data protection law. So I think those are the kinds of things that would empower the commissioner. And the big fines can be an important deterrent. Although, we'll have to see how they play out and how they work out, but they really are also imposed only after things go terribly, terribly wrong. And so, one of the goals of this legislation and its oversight should be ensuring that things don't go terribly, terribly wrong, or do so only as little as possible.
Yeah, and just to add to that, one of my concerns is that it's, I'd say, it's increasingly difficult for people to actually know whether something has gone wrong with their data, or even to know who has their data and what they're doing with it. I mean, one of the characteristics of the explosion of the data, particularly the data surveillance business, has been the growth of a huge ecosystem of let's call them brokers, for want of a better word, who capture information from various sources, and they package it and they sell it and in various ways, so that to improve the advertising potential, and a lot of that can be potentially abusive, manipulative, in terms of recommending material to you, content that is inflammatory, or at least gets people's attention in ways that it's hard to resist, even if they regret it afterwards and so on. And so one of the things I'd look for in the bill is actually much more in the way of information transparency, openness. I mean, that's one of the principles of the digital charter, which is supposedly driving this. It's the Digital Charter Implementation Act, and one of the, I think the third principle in the charter is control of your own information. And if you don't know who has it and what people are doing with it, then it's very hard for you to exercise control, and a lot of it is done outside anybody's reasonable ability to track. Do you have any thoughts on that, Teresa? I mean, we didn't get too much into the issues around consent. But.
Yeah, and the consent issues are really important ones in this legislation, and so one of the things that the government has done in this bill is kind of double down around consent. So consent is still at the core of the legislation, even though we all know the consent model is broken in some very fundamental ways, right? Because as I was mentioning earlier, there's so much of our lives are carried out in digital spaces now, and everything comes with a privacy policy, and we're being asked to consent to this and that, and we don't. Like, there's just only so much time in the day, and you often need your services when you need your services, and you don't have time to read the policies and so on. And so the consent model is largely broken. Even if you did read the policies, you might struggle to understand them or to understand the implications of those policies. And there's an interesting change in Bill C-27 from PIPEDA in that respect that we could talk about too. So the consent model still remains at the core of this, and with a series of exceptions to consent. And I'm not sure that fully responds to the reality of the situation, the needs that we have as consumers. And so there's certainly that issue. And then there's the quality of that consent that is given. And in many cases, I think it's an extremely poor quality consent because people have not had the time to read or think about the privacy policy. Hey, even if you did, you can't negotiate it, right?
Yeah.
It is what it is. You take the service or you don't. So I do think that that's a very big piece of this legislation, the framing of consent and exceptions to consent.
You alluded to the sort of somewhat dodgy character of consent and the changes from the previous bill. I mean, in PIPEDA, it's a requirement for consent that people be able to understand it, whereas in C-27, the notice just has to be written in plain language, which seems like an extraordinary step backward, and I can only assume that was done under pressure from business, because it certainly doesn't contribute to actually understanding, which is ultimately the test. And by understanding, I presume, as you sort of mentioned, to understand what the implications are. You don't have to understand every word in the agreement if you are reasonably assured that it's not you're going to be fine with the results. But putting in something only insisting on plain language seems like it's going to be a problem.
Well, it's interesting, and it'll be interesting to see how it plays out, because I think we might end up in a context where how this plays itself out is something like the Creative Commons licenses, where you have the plain language version, which is we share your data with these three companies, we do this, we collect only these data or whatever. It's something pretty simple and straightforward. And then referring the individual to the full legal text if they need to, making it clear that it's that long drawn out privacy policy to which they're bound, but here's the highlights in terms of what's happening with your personal data. That at least is an improvement in that it'll be much, if that's how it plays out, that'll be a much quicker snapshot of what's happening to your data. Clear, simple, straightforward, if that's how it's going to play out. And there's some advantage to that. But the the interesting thing about the current wording, which talks about understanding and the children's privacy that we were talking about, right, and how this bill is addressing children's privacy, is that the issue of understanding beyond plain language is if you are targeting a specific audience, and it could be children, but it could also be seniors, that the goal is not just to put it in plain language, but to put it to ensure that there's understanding of the implications and the consequences of giving consent in those circumstances. So it's a much higher threshold. And so if you're thinking about sensitive data and vulnerable populations, then maybe you do want to have that higher threshold for obtaining consent, where you have to be, sure that your target audience is actually capable of understanding what you're saying, as opposed to just having it set out in plain language. So there may be some merit to what is in the proposal in terms of those transparency requirements, but the understanding part, I think, is so important, particularly for more vulnerable populations.
Mm-hmm. Well, that was a very long, I thought, interesting response to the first question. Please do add your questions in the Q&A section. Andrew, let's take the next question.
Okay, the next question is from Neil. Neil says, C-27, similar to QC Law 25, Bill 64, is still weak in terms of requiring consent. At most, consent for a purpose is all that is required. And there is still blanket allowance for use of personal data for lawful purposes or when in the interest of business, including passing to other data processors or subcontractors without restrictions. It's clear that the bias is not to disrupt organizations with a business model of exploiting personal data or to limit innovation. What will it take for legislation to swing more meaningful consent, including much narrower conditions for use of personal data without consent, including lawful purposes, business interest?
Yeah, thanks. And that's a really interesting question. I mean, I think this is an area also where a human rights-based approach to privacy could really carry some weight. And so if you look at the legitimate interests exception, which I think the question is alluding to, it's an exception to knowledge or consent. So a business can can collect or use an individual's personal information without their knowledge or consent if it's for the purpose of an activity in which the organization has a legitimate interest that outweighs any potential adverse effect on the individual resulting from that collection or use. And so the language of any potential adverse effect is kind of, that's pretty squishy language as far as I'm concerned. Because you could, if an interpreter or a judge looking at that language could say, well, an adverse effect is one that, is harm to your person or your property, or, there's something measurable, tangible, compensable harm, something like that, that this is the adverse impact. And so, that's how this might get interpreted. And I think if you have a human rights-based approach and you use language instead of adverse effects, that you also use language of rights, then I think you right there have a much stronger limit on the scope of the exercise of that exception, because of course it can have an impact on your rights, your autonomy, your dignity. It can have these broader impacts that are often very difficult to quantify, and it might be that quantifiable thing that gets interpreted into adverse effects, not necessarily by the privacy commissioner, but remember, everything is appealable up to the data tribunal at a certain point. And so, I think that these legitimate interest exceptions in the legislation, they're trying to find a workable framework that, but if you don't have human rights as a backstop there, then I think you have a real, problem. It just becomes too open-ended.
And in the European General Data Protection Regulation, GDPR, which does have legitimate interests, it does have that human rights backstop. And so it looks like the C-27 has taken the idea of legitimate interest from the GDPR, but without that that backstop, as you say. And also they have another way out through implied consent. So it's unfortunate in that way, at least, and maybe that's something that could be fixed. Ange, next question.
Yeah, the next question is from Jayla for Teresa. Could you elaborate on your concerns about data anonymization being excluded by the Consumer Privacy Protection Act and about how it is being handled in the Artificial Intelligence and Data Act?
Mm-hmm. Yeah, so there are some, and this is one of those things. So there are some advantages to creating exceptions within the legislation for anonymized data. And one of them is it would encourage organizations to anonymize personal data if they're planning to hold on to it and use it for a variety of different purposes. So, and of course, if a company is retaining that data and using it for research or innovation purposes and it's anonymized, it's better protected in case there's a data breach. So it certainly creates incentives for organizations to anonymize data. The concern with having it out of scope is, of course, re-identification risk, and there are penalties in the legislation for attempting to re-identify data that has been de-identified. So that's clearly something that you are not supposed to deliberately do. But so there are still some concerns about what happens if it does become, re-identification is possible from these de-identified data sets, and what's the nature of oversight that's available for de-identified data. There's also the de-identification of data doesn't address the group privacy concerns. And of course, this is not legislation drafted to address group privacy concerns, but where is that legislation? Because the AI and Data Act, as it's currently drafted, focuses on harm to individuals and not harm to groups or communities. And so I think there's this other gap where you can have anonymized data that is just left ungoverned, and there are concerns about that and the implications for that. There are also indications, I think, that people are concerned about some uses of their anonymized data, and we haven't really had this conversation, although it's coming up in the context of healthcare and the use of personal health information and so on, and the idea that that there may be some context in which there could or should be public engagement or community engagement around uses of anonymized data. So I think anonymized data is probably a bigger topic than just for this legislation, and maybe we need other frameworks for anonymized data. One of those other frameworks obviously was seen as being the AI and Data Act, but as I noted, the AI and Data Act seems to be, again, focusing on individual harms and not a group or community harms, which I think is an important issue there as well. So those are some concerns. I mean, there's a very technical debate and discussion going on right now about whether the government has the wording right on de-identified and anonymized data, and there are, I think, some interesting issues about exceptions to consent for de-identified versus anonymized data that are also worthy of attention. I don't know, I don't want to go too far into the weeds there, but there are some uses, for example, sharing data without knowledge or consent that is just de-identified data as opposed to anonymized data. There is an exception for that if it's for socially beneficial purposes, and I think that raises a lot of eyebrows as well, because the standards for de-identified data are much lower. So there's a lot to comb through, I think, in the legislation. And I'll provide this for the resources page, but the Canon organization has done a really interesting review and critique of all of the provisions around de-identification and anonymization with suggestions for reform. So I'll make sure that that Ange has the link for that to put up with other materials after this video, if you're interested in looking at that more closely. I think it's quite interesting.
Good. Ange, next question.
Yeah, the next question is from Jan. What is the terminology for, quote, commissioner audits to be written into the bill if one wanted to write their MP?
Yeah, so the commissioner does have audit powers right now, but right now that's only where there's a reasonable ground to believe that something's gone off the rails. And so the language would really be proactive audit powers, so that the commissioner can be proactive and not wait until there's something's gone wrong. So proactive audit powers or proactive compliance powers more generally would be a good language to use.
Good, thank you. Ange, next question.
Yeah, the next question, an attendee asked, you've written a lot about AI and concerns about how it is being addressed in C-27. If you were asked to advise the government about what legislation should include to prevent serious harms to individuals resulting from AI, what are some of the key elements and which are missing from C-27?
Yeah. So the group privacy dimension that I mentioned, the group harm dimension, I think is a really important one, certainly in terms of the governance of data related to AI and the concept of harm for AI. But, for me, one of the things that I'm most troubled by with this AI and Data Act is the lack of consultation and public engagement. There are so many different issues in it and so many different questions, ranging from what should we be doing, who should be doing it, how should we, like, really fundamental questions where there hasn't been consultation. And I think where you'd find all sorts of interesting feedback and responses from different civil society organizations, from the public, from businesses, small and large, from researchers. I mean, there's a lot to think about and talk about here. And I think we need to have that public conversation. And sometimes it's really important for everybody to hear each other's views and concerns about the legislation, so that you can start to think about what it is that we want to do or what we should be doing, what the limitations and constraints are. I mean, like, just that transparency, that public process, I think, is so important when you're trying to do something as big as, for the first time, regulate AI. And so I understand the concerns about moving quickly and whatever, but there are public conversations that we need to have that are so fundamentally important in surfacing some of the issues. And I think, for me, looking at this bill, and I have a lot of questions and trying to figure out things, and I'd like to have those public conversations too. I'd like to have people in industry explaining what their concerns are. I'd like to have people in other sectors explaining what their concerns are. I'd like to have that more fulsome discussion. I think it's really important.
Good, thank you. This probably will be the last question, Ange.
Okay, the next question, an attendee says, on the topic of data brokers, the UK EU has a patchwork of legislation, GDPR, Convention 108, LED, and specific, that indirectly impact data brokers' unruly behaviors. European personal data is more expensive than American, for example, due to GDPR compliance. Do you see any way in which the CPPA will be able to address data brokers either by itself or in conjunction with other legislation?
Yeah, I don't think the legislation will help particularly with respect to data brokers, and they are really that's a very thorny problem. My colleagues at CIPIC, I'm so bad at acronyms, and this is at the University of Ottawa, our clinic, our public interest technology clinic, have done some really interesting and important work around data brokers, and I can also provide some links to that. But this is an industry that makes a great deal of money off personal data, and I think that there are legitimate concerns about the impacts of their practices on individual privacy. And so, yeah, I'm not sure that this legislation is really going to do much to change the situation with respect to data brokers. I think we need to have, a more fulsome consideration of their role and how they impact. Some of this discussion came up a little bit in the recent ETHI hearings around the parliamentary committee hearings around the mobility data, PHAC use of mobility data, because some of that data might have been sourced from data brokers, and there were some interesting issues about how can you be sure that people consented, and how could people even possibly exercise and opt out to the use of that data by the public sector if they were sourced in that way. And so I think there are a lot of really interesting questions in there around data brokers.
Yeah, I think the data broker issues is really an interesting one, and it's unfortunate, as you're saying, that the legislation doesn't really address it very squarely, because that is one of the I'd say significant areas that a modernized privacy law needs to address, since it's now so part of the data industry. So it's still not, this legislation is not forward-looking in that respect. So there's a lot of work to be done, and hopefully in committee, some of this can be raised. There's so much more that we could talk about. It's a very long and complex and really interesting and important bill, but we've run out of time, and I'm afraid there's one question we're not going to be able to get to. But I want to thank you very much, Teresa, for your time and your experience and devotion to these issues. And it's really been an insightful discussion, and I think quite stimulating. And I hope people will be able to take away some good ideas of what, at least to understand what we're getting into, and maybe even contribute to the debate. Tomorrow, Ange will post a recording on the podcast section of the Center for Free Expression's website, as well as its YouTube channel, and you'll find links to the materials mentioned in our conversation, and that we'll be adding some more as well for tomorrow. If you found this session valuable, please let others know about it. If you have any feedback of what you liked and didn't, suggestions for future topics, guests, and so on, please email us. The Center for Free Expression's email is on its website, and mine is andrew.clement@utoronto.ca. So we really would like to hear from you and what you think of this. So I hope you have found this as rewarding as I have. I've always appreciated talking to Teresa, as you might imagine. We'll likely have another event in the Taming Big Tech series, but we don't have a firm date yet. I hope you'll join me again when that happens. You can sign up for notifications again on the CFE website. So again, thank you very much, Teresa.
Thank you.
Good luck with your sabbatical and also your time at the Information Privacy Commission of Ontario. You're the first scholar in residence there, I believe. So I hope that's good for you.
Yeah.
And thanks, Ange, for setting things up, and thank you all for attending and asking interesting questions. So back to you, Jim.
Well, thank you. I want to join you in thanking Teresa. It was very informative. And as always, Andrew, you're a wonderful host for this ongoing series of really important questions that we as a society need to be addressing. I want to thank the audience as well for your engagement and your questions. And as Andrew mentioned, a video of today's conversation will be posted on the CFE website tomorrow, along with a list of other resources for those of you who are interested in reading more or seeing YouTube videos or whatever more about Bill C-27 and the issues it raises. The CFE's website is cfe.torontomu.ca, cfe.torontomu.ca. The next event that we'll be hosting will be in the new year. It will be on Thursday, June 19th at 3 p.m. Eastern Time. And
do you mean January or
what
June?
did I say? Sorry. Yes, Thursday, January 19th at 3 p.m. Eastern Time. And the title, it's a very different topic, is Canada's War on Whistleblowers. In more than 15 years of operation, and costing over $100 million, Canada's federal whistleblowing law has not protected a single whistleblower. In fact, the law has made their lives worse. And this panel of leading experts on whistleblowing in Canada will be looking at why this is, what this has meant for the public, and what can be done to protect those who speak up in the public interest. So I hope you'll join us Thursday, January 19th, 3 p.m. And for more information about the many events the CFE has held, our additional future events, and issue and information and resources relating to all of the issues around which we have events. Again, go to the CFE website, cfe.torontomu.ca. Thank you all for joining us. Goodbye.
Bye-bye.